Yena ni nyoma esi wo Parliament House enra. Wa bra Afenyo makin Bible nti be de kan sem bebre because of eye Baffo Bonni na ye vetting e wo honom no. At the end of the day no, ye beti ase ase Afenyo makin e sane ma nyina because of toku no. Enti a wo kire mu se kwa ye fa so a ye yi toku no adi asije no ne entwa yi a wode ne reasons ba ya busuya ye hu se reasons na Afenyo makin de ba ye no enche da nye concrete like any understanding bia na nde. Oh, good morning, Ghana. So the youngest NDC NP, Honorable Agbena, Eba Wantene, Ebe Kansembi. Oh, good morning, Ghana. So Wabra, Wane Muru, Edin Kombo. One NPP communicator, and Nico Shemu Honum. Now, and some NPP communicator, ne kind the beauty dance here say, Nyoma for Nyoma can a year of Parliament House and run one day was supporting. So, look, I can't adjune, edit a year rubber for Bonni no. NPP communicator na chire mu say nyo Afenyo makin ni nyina wo support na busu aka senso bo wa enke say pete Agbena chire ne say we young na emum no na adwene mu edok kan adwene chire no including Afenyo makin me pese me kasa bri no enhwe video na mbra I malikbasintale TV so bo ho mo subscribe share no benya video ni bi enhwe
bro. Yesterday what happened in Parliament me was just one of those regular days in Parliament when a committee of Parliament exercised their mandate and they did it well. Whether there was a boycott, there was a walkout, or whatever we choose to call it, because I'm reading other reports where some members of the NPP are saying that they voted en bloc against the nomination and that it wasn't a walkout or it wasn't a boycott. Others are also saying that there was a boycott or there was a walkout. But whatever it is, all of those things are part of the parliamentary process. Boro, you may not be aware, but when you go to Ghana's parliament, and traditionally most parliaments, even the sitting arrangement had a history. The Westminster system, Parliament of UK, where Ghana, drew its inspiration from, the space between MPs was the length of 2 swords, because they, out of experience, anticipated that there could come a time where members could flare up and get angry and decide to throw swords at each other, and so the distance, sitting distance, the space was created such that even if it happens that my senior brother, the Honorable Tampuli, and I decide to throw swords at each other, the length will not permit us to hurt each other, something like that. And so there's always this level of disagreement in Parliament across the world. In fact, just yesterday I learned somewhere that when you go to Uganda now, they have screwed their seats because they have had situations where members of Parliament, it got chaotic and they were throwing their seats at each other and all of that. So the level of disagreement that we saw yesterday is normal. I don't think that there was a problem with it. As to whether there was a walkout or what have you, it's not even the issue. But the question is, what was the issue or the issue of contention? What was the bone of contention? What was the disagreement all about? Everything that happened yesterday and everything that the majority leader and leader of government business, the Honorable Mahama Ayariga, did and said was in line with either the constitutional provisions or the provisions of our standing orders. Moro, I will go into the issues. Let me state it, and I think it's important for us to properly put this conversation in context. The qualification of Justice Baffo Bonni is not in contention. And nobody, not even his critics, our friends in the NPP minority, are not raising issues with the qualification of Justice Baffo Bonni. And that must go on record. Because the qualifications are well spelled out in the Constitution, and he has met every single requirement to be appointed a Chief Justice. And so that is not in contention. Whether it is the number of years at the bar, the experience, and what have, he's met all. So it is not in contention. Number two, the processes leading to the appointment of the Chief Justice is also not in contention. Because Article 1441 clearly states that the President, in consultation with the Council of State, will appoint the Chief Justice. The President did that. Letters were sent to the Council of State as confirmation. Nobody has been able to, throughout all these conversations, accuse the President of breaching any aspect of the Constitution in appointing Justice Baffo Bonni as or in nominating him for appointment as the Chief Justice. When you follow the constitutional provisions, after the nomination is made by the President, he has to be vetted by Parliament or subjected to an approval process. Now, the approval process, and let it be known, is not necessarily a vetting. Parliament is the master of its own rules. Parliament could have decided, if we wanted to abuse our numbers, our majority, we could have decided the format for the approval. Because the Constitution states that will be subject to approval by Parliament. And so we, using the appointment committee of Parliament, which is a standing committee, subjected him to vetting and order. And there are many cases, and I am not a lawyer, at least not yet, but there are many cases where Parliament could have decided any other means of subjecting him to or vetting his competence. So his competence is not in question, his qualification is not in question, the procedure for the appointment is also not in question. So what is in question is about whether or not we should allow the former Chief Justice go on with litigation. Let the lawyers know. Litigation must come to an end. You have gone to... she has gone through various... She's gone to court on several occasions. And as we speak today, nobody has been able to point to any provision of Article 146 that was breached in the process of removing her as Chief Justice. Nobody. I am willing to learn. Show us. This is the Constitution. Which aspect of Article 146 has been breached, Moro, in appointing or in the removal process? None.
He's just told you.
Indeed, no. What he described as opaque.
He said.
What he described.
As we speak, Tokano doesn't know the basis upon why.
Oh, please, please. We can't say that he doesn't know the basis.
The Premier.
What was he responding to? But he responded.
Let me just read something for you. Let me just read something.
What is he responding to?
Let me help you. Suit number HR /0115/2025. Chief Justice Gertrude Abarabato and Article 146 committee set out to hear petition against Chief Justice and Justice Scott Parman, Justice Dibu, Yao Demolevo, Major Flora, Professor James. And the process is that application for judicial review pursuant to Article 23 and 141 of the 1992 Constitution and Order 55 of CI 47 to quash proceedings of 15 May 2025 on account of 1. Violation of all the alteram partem rule of natural justice by committee's refusal to recognize legal representative of CJ and accord him a hearing on case management meeting. 2. Refusal to disclose to Chief Justice the case referred for inquiry against her. Refusing to serve the Chief Justice with the documents referred to committee by the President, including the alleged prima facie determination. So what I'm saying is that if you look at Article 146 architecture alone, you miss the point. But the devil is in the details.
Great. So
you understand?
So she has no problem.
Constitution provides for it. But how you operationalize it?
My point is that what you have read,
yes,
what you have read is the case that she has taken to court. That is her belief. But I'm saying that when you read the entire constitution, and you take a look at Article 146, which spells out the procedure in removing not just the Chief Justice alone, but also a Justice of the Supreme Court. In my, there is no breach of any of those provisions. The issue of opaqueness, and Senior made the point that the Constitution itself make that process opaque. Or the Chief Justice, or let me say the former Chief Justice, who, having practiced as a lawyer for several years, rose through the ranks, became Chief Justice, went to court, asking the court to do what was clearly a breach of the Constitution. When you read the Constitution, in the matter of whether or not such a committee should sit in camera, it was not at the discretion of any individual. The Constitution said, shall be held in camera. But she went to court asking that what the Constitution says shall be done should be waived, so that for her, it should be done in public. For me, the very day she went to court seeking that particular provision to be breached, I actually questioned the integrity with which she led the judiciary. Because the Constitution says, shall be held in camera. And all of a sudden, that is what we are standing on to say the process was opaque. Please, I believe, and going through all of these things.
But was it not opaque?
No, the process was not opaque. She had her day. She appeared before the committie. She responded. Then, though in camera means that it must be held, without without the view of the public.
Exactly. That's what opacity is.
And I'm saying that it is what the Constitution provides.
That's what opacity is. Exactly. So
the framers of the Constitution may have a reason why it is stated in that. And when she was Chief Justice, she did not have a challenge with that provision until it was time for her to appear before the committee. Then she was now raising issues with what was the constitutional provision. And when you read the Constitution carefully, there are aspects or provisions of the Constitution where discretion is allowed. But in this case, there's no discretion. It says, shall be held in camera. It means it is supposed to be held in camera until there is a constitutional amendment where that provision is changed. It must remain so. It must be held in camera.
That's fine.
If that is what appears as opaque to her, I'm sorry, but that is a constitutional provision. Okay. Having said that, yesterday, the issues of the standing orders. It is true. Some of us are quite new in the house. But we took the advice that leadership gave us when we came, that you need to learn the standing orders and imbibe it. You need to, religiously read it as though it is such a sacred, for you alone, like the Bible or anything like that for you. According to our standing orders, Order 123, what the majority leader, the Honorable Ayariga, did yesterday was right. Order 123 provides for what we call content of speech. Now let me give you Order 123.2. It says that a member shall not A. Use offensive, abusive, insulting, blasphemous, or unbecoming words on a member or any other person, or 2B. Impute improper motives or impugn the integrity of a member or any other person. So based on this, the majority leader says, describing the nominee as disputed, it could qualify as impugning improper motive, or you impugn the integrity of the nominee, and for that reason may not be acceptable, and that should be removed or expunged. And all of that are provided for in the Constitution, in the standing order. Because 1233 actually states that where in the opinion of the speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugn the integrity, blah blah blah, the speaker may order that the member withdraws those words or withdraw and apologize. And so the majority leader, based on this, was asking for the withdrawal of the word disputed nominee. And that was it. Clearly, we saw what he did, and it's in line with our standing orders. Again, when you go to standing orders, Senior made reference to the 7. But beyond the 7, before the 7, there's a 6, which says, the speech of a member shall be relevant to the subject matter under discussion. So, a nominee appears before the committee. Yes, it has been a practice that the chairperson of the committee will allow the ranking, sometimes even the vice chair, to make preliminary comments before the commencement of the committee's work. So it happens across all committees. But based on 1, 2, 3, 6, that comment must also be related, must be related to the subject. And so if I appear before the education committee and I'm acting as the chairman or the vice chair, and I'm giving the opportunity, let's say Get Fund appears before us, and in my preliminary comment, I begin talking about Metro TV or talking about National Service Scheme, which is not related to the subject matter. Based on this, the speaker, and the committee sitting is an extension of Parliament, and so all the rules applies. So based on this, the chairperson or the speaker can call me to order and say that my speech should be related. Number 2, when you read the same standing orders.
So this point that you just made.
So the point I'm making is that there was a nominee before the committee. So if you are given the opportunity to give preliminary comments, ideally it is expected that the comments should be related to the side, which was the vetting. So when you go on, and again I will go to that standing, when you go on to discuss a matter even for which the House has already concluded, and that is also provided for in the standing orders. Look at 5. 1, 2, 3, 5 says, a member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. Last week, Friday, during the presentation of the business statement for the ensuing week, this matter of Chief Justice nominee and whether or not the vetting should come off was extensively deliberated upon. The Right Honorable Speaker, the Honorable Alban Sumana Kingsford Bagbin, passed a judgment or gave a ruling, that's how it's properly said, gave a ruling on the matter and brought the matter to conclusion. So 1, 2, 3, 5 of our standing orders says that a member is not allowed to raise specific question upon which the House has come to a conclusion, on a matter. So we have already concluded, or there was a ruling on that matter, and so we could not have stopped the appointments committee from proceeding to do their work. Then again, there's another issue. When the Speaker was giving his ruling on Friday, last week Friday, there was this issue of whether or not what is happening in one arm of government should impede or prevent Parliament from exercising its mandate. And the Speaker made a very simple analysis: separation of powers and judicial independence should not mean legislative paralysis. What he simply says is that the fact that there is a matter before the courts awaiting determination does not mean that Parliament will not be allowed to do its work. Does it mean, drawing from that analogy, does it mean that today, if I decide to go to court to place an injunction or seeking something related to the budget reading, so Parliament could wait for how long until the court is determined? There is a reason why we have a history with how these things are done. As long as Parliament is not in contempt of court, as long as Parliament has not breached any laws.
Let me help him with. Can you take a look at Order 103F?
Yes.
What is the scope and effect of Order 103F?
I can go there. I can quote it for you.
Yes, read it. Read Order 103F.
Order 103, yes. So, yes. So this is Order 103. That's conditions for admissibility of motions. The F says, be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the speaker. So the top says that a motion shall relate to a definite issue and not. But in this case,
so what does that F say?
The F says not be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the speaker, prejudice the interest of parties to the action.
What's your understanding of this one? If there are pending cases in court,
so if there are pending cases, so my position is that
the three arms of government are separate, independent, equal, and coordinate in status.
Exactly.
All right.
Exactly.
So what you do is that when there's something going on within the judicial arm of government, cases are pending. Good sense and civility and, comparative practices across the jurisdiction where we learned this democracy.
So let me finish. I know the angle you are going, but I'll finish. Moro, I know the angle he wants to go, but let me finish. Moro,
the resolution of the matter in court. Moro, you understand? And that is what we have adopted.
And we are saying that.
Do we pick and choose?
Moro, we are not. There's no pick and choose. In this case, so let me. In this case, there was a ruling on this matter on Friday. The Right Honourable Speaker gave a ruling. And in the ruling, Parliament is allowed to go. And then let me say that the issue in court is not even about whether or not the nominee is qualified to occupy the position. It is about somebody who has been removed from office, who in her understanding of the processes was not fairly dealt with, and is in court. So are we saying that Parliament's work should come to a halt because Justice Tokuno gets a conclusion?
The counter argument is that can you imagine a situation where Justice Tokuno gets a favorable judgment in court? Can you imagine that situation? And say she should be restated as the Chief Justice of this country?
Can we imagine?
What will happen?
So can you imagine if Justice Tokuno's case in court travels for how many years? The point is that as we speak today, with regards to our standing orders and our constitution, there is no breach of the constitutional provisions in the nomination of Justice Baffo Bonni. There is no breach in our standing orders in how Parliament conducted itself yesterday to do the vetting. A report will be presented to plenary, and members the House will take a decision on it.
All right.
But as we speak, I can say confidently that Article 146 was adhered to strictly in the removal process. Article 144 was adhered to in the appointment of Justice Baffo Bonni. And all the standing orders, relevant standing orders, in relation to the vetting process has been adhered to.
All right.
And so Parliament will continue to do its work.
Right.
And I believe that when the committee brings their report, yesterday, we saw how the Chief Justice nominee discharged himself excellently.
All right. So we'll come back. We'll come back and look at some of the